Welcome back. We have spent a lot of time discussing how to write a will and what to put inside it. But today, we are going to ask a counterintuitive question. Do I actually need a will? The answer might surprise you. While a will is a vital fail-safe for your plan, it is possible to structure many of your most valuable assets to never even touch your will. They can use a different path to reach your loved ones. This lesson is about understanding what happens if you have a will, what happens if you don't, how some assets may move to people without a will or probate at all, and identify whether you want to avoid probate fully, partially, or not at all. By the end, you won't just have information. You'll have a framework for deciding what approach fits you. Think of your estate like a journey across a river. A will is like a sturdy ferry boat that carries your assets across under the watchful eye of a captain, the probate court. It's safe, it's supervised, but it takes time to load and unload. If you don't have a will, those transfers still need to occur, but rather than you providing the instructions, the laws of intestacy go into effect. It's essentially a preset formula for who gets what. So let's progress through your several options, from doing nothing to avoiding probate entirely. So first, let's talk about what happens if you choose to build nothing at all. If you decide not to have a will, and you haven't set up any automatic transfers, you fall into a state called intestacy. Intestacy is essentially the government's default plan for you. Your estate goes through the same probate process, but in this case, the state chooses a person to administer your estate, ranging from family members to beneficiaries, and could even be a creditor who wants to be paid. The court uses a strict mathematical formula to decide who gets what. The law doesn't attempt to determine what each person deserves. It's possible someone you never even knew could inherit, and if the court cannot find your heirs, everything could go to the state. On the other hand, if you have a spouse or children, no one else is likely to get a thing unless you've spelled it out in a plan. If intestacy is the first option, creating a will and transferring everything through the will is the second option. As previously discussed, your will chooses who should administer the estate and how you want your assets divided during the probate process. But what if you don't want to go through probate? Is it possible to bypass the court process entirely? This is where we use will substitutes. These are ways to transfer property through operation of law or operation of contract, instead of through court involvement. These ways take precedence over your will and over state default rules. One common way is to change how property is owned. The most common is joint tenancy with right of survivorship. You probably already use this if you own a home with a spouse or have a joint bank account. It's like a game of last person standing. When one owner passes away, the other owner automatically becomes the sole owner of the entire asset. No court, no probate, just a clean transfer. If you're married, you might use a special version called tenancy by the entirety, which offers even more protection from creditors in some states. A second way to bypass probate is using beneficiary designations. These are common for life insurance, annuities, and retirement accounts like an IRA or 401k. When you fill out that form at the bank or with your insurance company, you are creating a legal contract. Upon proof of your death, the institution is legally bound to hand that money directly to the person you named. It completely skips the probate process. You can even name a contingent beneficiary, a backup person, just in case your first choice isn't there to receive it. Then there are payable-on-death or transfer-on-death provisions, often called POD or TOD accounts. These are incredibly simple. You keep total ownership and control of your account during your life, but you designate someone to receive it the moment you're gone. This designation is available in many states for bank accounts, investment accounts, and some states even allow this for real estate through a transfer-on-death deed. Finally, there is the living trust. Think of a trust as a container. You fund the trust by moving your assets inside it while you're alive. Because the trust, not you, technically owns the property, there's nothing for the probate court to transfer when you pass away. Your successor trustee just steps in and continues to manage the assets based on the rules you wrote down. Because of these tools, some people build an estate plan that relies mostly on will substitutes and only uses a will as a safety net. Others prefer a will-centered plan. Many people land somewhere in between. So, here's the big question. Do I want to avoid probate? Avoiding probate can have benefits. Transfers may happen faster. There may be less court involvement and possibly less costs. Some people value privacy, but probate also has a role. It creates a supervised process for resolving claims, paying debts, and formally closing the estate. A formal probate process can cut off late arriving creditor claims more quickly than a trust can. Some people even choose to put a small amount of money through probate just to use that legal shield to protect the rest of their estate. There are also trade-offs to will substitutes. Beneficiary designations and joint ownership need regular updates. If circumstances change and paperwork doesn't, assets may go to someone you didn't intend. Some arrangements can accidentally override your broader distribution plan, and putting someone on an account today may give them access today, not just later. The perspective shift for today is this. Your estate plan is a collection of tools, and you get to choose which one is right for each asset. You might use a living trust for your house, beneficiary designations for your retirement, and a simple will as a catch-all safety net for your personal belongings. So, now you know that you have options. If you're ready for a small immediate step, I invite you to look at your accounts and property deeds. Just check to see how they are titled. Are they in your name alone, or is there a joint owner or a POD beneficiary? Just knowing how those assets are currently structured is a huge move toward control. For those who want to go deeper, there are optional resources that can help you review beneficiary designations, understand state-level differences at a high level, and organize this information in one place so it stays current. You are doing great work building a structure for your future. Keep going.